Here to explain how regulators attack dealer aftermarket product selling and how to protect your dealership is Randy Henrich, president of AutoDealerCompliance.net. Please give him a warm welcome.
Hello, and thanks for joining us today. My name is Randy Henrich. I'm an auto dealer compliance and regulatory counsel. I work out of an office in New York. I was formerly DealerTrack's head regulatory and compliance counsel for 12 years. And we're going to talk today about a very important subject, the subject that's really going to be the next big thing in regulatory and compliance, and that's regulators going after dealers on dealer aftermarket sales. Before we get to that, this is along the lines of a dealer's advertising disclaimer at the bottom of a TV ad, so I'll give you as much time to read it as they do. Here's the short version. This presentation is not legal or compliance advice, since I don't know you and don't know your specific facts, but it will raise issues that you'll want to take home, consider with your legal or regulatory people, and put into your practice. It is for information purposes only. There are handouts that go with this presentation. You can get them from the link at the end of the presentation, and they will include a form that I'll be talking about later, so you may want to do that. Let's start the presentation. Let's just watch a little aftermarket presentation here.
Congratulations on your new car, Mrs. Miller.
Oh, thank you so much. I'm so excited.
Is there anything else I can get for you today?
You know what? How about a spoiler?
Spoiler. Do you know how hard it is to get a spoiler around here? First, I'm gonna have to call parts.
Please hold.
They put me on hold every time. They tell me the spoiler's gonna be $3.99.
Yep.
They'll transfer me to service. If Chuck answers, it'll probably only be $100 in labor. But if Matt answers, it could be $200 in labor plus. I'll just quote you around $800 for your spoiler. Once they get the part in, you'll drive all the way here, just for the parts department to tell me it's the wrong color. You just missed little Susie's soccer game. And you know what happens to my commission? It goes flying out the window. You'll come back to get your car, and you and little Susie will be on your merry little way. Meanwhile, my dealer's looking over the books and says, "Who authorized this spoiler? That was supposed to be 4 hours instead of 2. Well, guess what? I'm upset too. Who's gonna pay for it? Me. It's all your fault, because you wanted a little spoiler on your car.
Well, that's probably not your typical aftermarket sale product, but thought you'd enjoy that. Probably some regulators think it is, based on what they've been doing in the aftermarket space. That concludes the humor portion of our program. Now we'll get to the good news portion of our program, which in my programs is usually pretty short. The good news is that we have won the battle on the CFPB's claim that flats are the only way dealers can be compensated for financing automobiles. The CFPB has backed off that position. They started it in 2013 in the guidance. Their last 3 consent decrees with Honda Finance, Fifth Third Bank, and Toyota Motor Credit have all permitted dealer rate participation. Now, it's admittedly at 1.25% up to 60 months, 1% after 60 months, but the lender can supplement it with an additional payment that'll get you to the same place. So this is a great victory for the auto dealer industry. Of course, there was never any legal or factual support for the position that flats were the only way to compensate dealers, but it's good to win one. And what it's done is it's caused the CFPB to shift its gears. They're looking at other ways to go after auto dealers, other profit areas. And the one at the top of the list, and where they're going next, is aftermarket product sales. They have the same arguments they had for rate participation, disparate impact credit discrimination, that women and minorities pay more, get worse terms for aftermarket products. Those arguments have the same defects as they did on rate participation, but they also have a stronger weapon, and that's the weapon of unfair, deceptive, and abusive practices in the selling process of the aftermarket products. Didn't have that with rate participation. Rate participation was purely about numbers and statistics. that didn't make any sense. Here, they're going to look at the manner and ways that you sell products and characterize them as unfair or deceptive. And in doing that, they're partnering with the FTC and state attorneys general. And there have been some big penalties imposed. We're no longer in the day when fines and penalties were $15,000 or $20,000. In one case, a dealer paid $14 million in fines and penalties and reimbursements. In another case, $2.7 million. And as we'll talk about a little more later on, the FTC for the first time is looking to impose personal liability on dealer principals. And this is a new development consistent with what the Department of Justice announced in 2015 that they wanted to do with wrongdoers in other areas of the law. How do they do this? Well, there's a concept called regulation by enforcement. The way agencies typically publish regulations is through the Administrative Procedures Act. They publish proposed regulations in the Federal Register, they take comments for a period of time, and then they publish the final regulations. That process has been put on the back burner to a large extent by the Consumer Financial Protection Bureau and now the FTC as well. Regulating by enforcement simply means we know bad acts when we see them, and you're liable for them, even if there's no prior law, no prior enforcement action, no prior case decision that says they're wrong. An example was in 2015, the FTC brought an action against 5 dealers claiming that their advertising that will pay off your existing vehicle loan on, as part of a purchase was deceptive. Now, they qualified it properly in the footnote that they weren't going to pay it out of their pocket, it would be financed. But the FTC considered that deceptive advertising and slapped those dealers with 20-year consent decrees. So in the regulation by enforcement world, pretty much everything is fair game. Here's what CFPB Director Richard Cordray said about it. He believes it is, quote, compliance malpractice for other institutions not to look carefully at our orders and not to think, am I doing the same thing? Am I violating the law? And therefore, should I clean that up? He added, that's a basic of consistent law enforcement. People call it regulation by enforcement. I call it good, solid law enforcement. And this is going to continue during the Trump administration. And I'll tell you why. There's a law called the Congressional Review Act, which gives the Congress an expedited procedure, no filibusters, to look at agency published regulations and overturn them. The Congress could pass a resolution of disapproval. And they did so several times during the Obama administration. And if it's signed by the president, the regulation is null and void, and the agency is precluded from creating a substantially similar regulation. So if, for example, the CFPB publishes its regulation on arbitration proceedings, that you can't have class action waivers, we've got a Republican House, a Republican Senate, and a Republican president. What are the chances that that regulation, adopted in the familiar way, will be overturned? Very good. But the Congressional Review Act doesn't apply to regulation by enforcement. It doesn't allow Congress to overdo enforcement actions. And that's why you're going to see more regulation by enforcement and less regulations by publication. And that's not a good thing for dealers, because it puts, theoretically, everything at risk. So the next frontier after rate participation is aftermarket products. And there are multiple legal theories to attack them. We mentioned disparate impact. Women and minorities get worse terms than white males. But they also have a broader, more general, and more subjective standard called unfair, deceptive, and abusive acts and practices. An unfair practice is a practice that causes or is likely to cause, in the regulator's view, injury, a substantial injury to consumers and isn't outweighed by any countervailing policy. So nobody has to actually cause substantial injury, but if the agency believes it could happen, they could slap a 20-year consent decree on you for that. A deceptive practice is a omission or practice that misleads or is likely to mislead a consumer. That's what they cited in the case with the advertising that will pay off your trade-in. Nobody was misled. There was no complaint about it, no evidence of any prior action saying that term was deceptive. But in regulating by enforcement, it's whatever they want, whatever they think. Dodd-Frank gave the CFPB authority to regulate what's called abusive practices. And the FTC, your principal regulator, has said abusive practices are a subset of unfair practices. Let me tell you what those are. Those are any practice that materially interferes with the ability of a consumer to understand the term or condition of a financial product or service, or that takes unreasonable advantage of. I guess you can take reasonable, but not unreasonable advantage of a lack of understanding on the part of the consumer, the inability of the consumer to protect their interests, or the reasonable reliance by the consumer on a covered person, that's a dealer, to act in the interests of the consumer. Now, I hope people in your dealerships aren't telling consumers, don't worry, I'll get you the best deal, because that sounds awfully close to that last prong of abusive practices. And it's already happening. Enforcement actions are already starting, and they're coming in big numbers. Remember that the Dodd-Frank Act gave the Attorney General of this country the ability to enforce federal as well as their state laws. And in fact, the National Association of Attorneys General has a working subgroup called the Auto Finance Subgroup that looks at ways and socializes on ways that they can all go after auto dealers. The New York Attorney General settled with a 20 dealership group for jamming questionable F&I products, credit repair and identity theft prevention that were offered through a third party for more than $13.5 million. The AG called these services frequently worthless. Only a small percentage of the consumers use them. The CFPB went after U.S. Bank in an enforcement proceeding for selling vehicle service contracts for, quote, only a few dollars a day, and Gap for only a few cents a day to military members. Now, military members are the favorite constituency of CFPB and the FTC. So you really need to be careful when you deal with military members. But the few dollars a day came out to $43 a month. That sounds like a few dollars a day. Nothing deceptive about that. And the Gap was 42 cents a day. Maybe that was more than a few cents a day, but those two statements and those prices were considered deceptive and abusive according to the CFPB. In September 2016, the FTC sued an 8-group dealer in California. More on this case a little later. And they charged, among other things, that the dealers packed extra unauthorized charges for add-ons that included extended warranties, guaranteed auto protection, or GAP, and service plans. The FTC alleged the dealership violated the unfair and deceptive practices provision, Section 5 of the FTC Act, by charging some consumers for add-ons without their consent or falsely claiming the products were required or were free. The CFPB, in its 2016 summer highlights, found several lenders to have been deceptive in ads for GAP and payment deferral terms. On GAP, the customers were told that if their vehicle was stolen or totaled, the GAP would pay off the obligation. But the GAP policy itself only paid a certain amount below a certain loan-to-value ratio that was figured algorithmically somehow, leaving the customer with payments when they thought they'd be covered. The dealers also created a false impression about 90 days no payments, where the interest runs but you don't have to make a payment, by telling the consumers that the only effect of that was 90 days of interest. Well, in fact, if payments are applied first to interest or finance charge and then to principal, over the life of the credit obligation, they were wildly understating the total of finance charges. That too was considered unfair and deceptive, and they entered into considerable settlements for that. See, the CFPB considers auto dealers to be service providers for lenders, and who's going to tell them they're not? Nobody has. Nobody, at least officially. Here's my favorite request by the CFPB for sharing information about aftermarket products. The Bureau has found or alleged that some companies are offering ancillary products and fail to accurately describe those products. And some offered products that provided little or no benefit to consumers without disclosing this fact. Now, what company sells its products and services by announcing that they provide little or no benefit? I don't know of one, but the implication seems to be from the CFPB that that's what auto dealers have to do. I hope that's not what they mean. They did indicate that since they opened their online website for complaints in 2011, over 60% of the complaints they had received involved auto financing. Now, many of these were farmed immediately out to the FTC or state attorneys general. But many consumers expressed a lack of understanding of the terms of their credit sales or leases. And their examination procedures for lenders in their lender audits tell lenders to look for assessing other risks to consumers that aren't governed by specific laws or regulations, which may include, quote, potentially unfair, deceptive, or abusive acts and practices with respect to lenders or services interactions with consumers. So the auditors are out there auditing lenders, looking for it. The standard seems to be pretty high for what you have to do, and we'll see where that goes. So what's really going on here? Well, I can tell you that the CFPB hates add-on products almost as much as they dislike auto dealers. They've killed the credit card companies with this. You know how when you call up to activate your credit card, you're asked that you want credit life, disability, payment protection, identity theft protection, all that stuff before you can get them off the phone. Same issue with aftermarket products in auto. For example, $200 million in fines were assessed against 2 credit card issuers. And every customer who bought one of the products, every single one, was given a full refund plus interest, even the ones that used the products. The CFPB also required those card issuers to have detailed policy statements about unfair, deceptive, and abusive acts and practices, and make disclosures and create an administrative nightmare. The CFPB genuinely believes these products have little or no value to customers, and their idea of value is in large part how much the dealers have marked up the wholesale cost of the product. Now, put another way, the dealers are making too much profit selling worthless products. Now, when I go into Burger King and I buy a soda, what kind of markup do you think they have? I think it's probably pretty extensive. But dealers don't get that benefit. I can't tell you where it becomes unfair, deceptive, or abusive. I think 100% markup, the traditional retail standard, might be okay. I know there have been cases that have said a $200 wholesale cost that was marked up to $2,000 was not fair and reasonable, and it's going to be case by case. And it's going to be a question of the value of the product in relation to its cost. If you take nothing else away from this presentation today, know the value of your aftermarket products. Look at each product, what its value is in relation to its price. Good example is an extended service contract. You know, the days of fixing automobiles with nuts and bolt wrenches is over. There are so many computerized parts within the system of a vehicle that a breakdown is probably going to cost a replacement of that part in several $1,000s. In that scenario, an extended service contract probably has good value to customers. If you're selling vehicle etch for $600 or $700, that may be a different story. The CFPB has warned consumers. Sales tactics may be high pressure and confusing, and the benefits you receive from the product may not match the benefits you thought you were offered. And the CFPB views credit card add-on products and automobile sales add-on products the same way. Dealers don't accurately describe them. I gave you the quote about offering products that provided little or no benefit to consumers without disclosing this fact. Their words, not mine. The CFPB sued a buy here, pay here dealer who required credit consumers to purchase a $1,650 automobile repair policy and a $100 GPS payment reminder device. Now, there were a lot of other things going on in this case, but the CFPB claimed the dealer took unreasonable advantage by exploiting its customers' misunderstanding of the credit and sales terms for its own financial benefit. Now, that's also a truth in lending violation, because when you require a credit customer to buy something that you don't require a cash customer to buy, and you shouldn't be requiring anybody to buy anything, but if it's a credit customer only, the entire cost of that product has to be included in the finance charge and the APR adjusted accordingly under truth in lending. And if you violate truth in lending, it's $1,000 a pop and class action liability. But it's also a deceptive trade practice in this case. The CFPB entered into a consent decree with the buy here, pay here dealer, ordering a refund to every consumer who bought one of the products, up to $700,000. And if the amount of the redress is less than $700,000, the dealer has to pay the difference to the CFPB as a disgorgement penalty. No refund to the dealer. Similarly, if a regulator were to determine that you charge credit customers more than cash customers, you could have a truth in lending issue. You could have an unfair deceptive practices issue. How do they get at dealers? Remember Dodd-Frank gave franchise dealers an exception from the CFPB? Well, they've been trying for 4 years now to indirectly regulate dealers. First with rate participation, now with aftermarket products through their lender audits. They believe, as I said before, that dealers are just service providers for lenders. They're of course not, but who's going to tell them? And if the lender finances it, they have jurisdiction over it. This is part of their continuing effort to indirectly regulate automobile dealers. And it's not going to go away because there's too many people in the rank and file who want to do this, have been doing this, and will continue to do it no matter what happens to the director, Richard Cordray. Disparate impact is the lead claim, but again, as we mentioned earlier, with aftermarket products, they have the unfair, deceptive, and abusive practices weapon. The FTC, also involved here. They plan to conduct a qualitative study of consumers who recently purchased and financed vehicles at auto dealerships. They're going to conduct 90-minute interviews with 40 to 80 consumers, spread out on credit score from prime to subprime to below prime to above prime, racially diverse mix, men and women, all ages, both sexes. And the proposed 90-minute interview will include questions about additional products or services the dealers may have offered. I think I see where this one's going. The FTC said, while the results will not be generalizable to the US population, and gee, I hope not, from 40 to 80 people, the Commission believes that they can provide useful insights into consumer experiences and understanding of the automobile purchasing and financing processes at the dealership. Huh? That sure sounds like they're making it generalizable to the entire population. We'll have to see where that one goes. As I said before, Regulators equate value with wholesale markup. You've got to be able to defend the value of every single aftermarket product you sell. And if you can't defend the value, don't sell it. We'll talk in a little bit about the ones the regulators particularly hate. New York Attorney General Eric Schneiderman said, "New York consumers must beware. Car dealerships sometimes pad their pockets by charging for worthless after-sale items which inflate the price of the car. These items are often ones that consumers don't need, did not ask for, and often are not even told about. Businesses need to make a profit to survive, but it's illegal to do so by duping consumers." So it's not just the FTC and the CFPB, it's state attorneys general. The FTC in 2015, as part of Operation Ruse Control, entered into consent decrees, 20 years, involving an aftermarket program in which the consumer was given the opportunity to make half a payment every 2 weeks instead of their full payment once a month. And that supposedly would save on finance charge over the life of the contract. Well, they forgot to tell consumers, or at least the FTC felt, that the majority of consumers wound up paying more to participate in the program than they would realize savings on their finance charges. And that was considered deceptive. The New York Attorney General, since 2015, has settled for over $17 million in fines, penalties, and reimbursement with dealers on aftermarket product sales. Texas, the District of Columbia, and California have also been very active. And remember, there's a National Association of Attorneys General that meets twice a year and goes over all this stuff so they can take it back to their states as well. The regulator you're most likely to see is going to be your Attorney General, because he's got the most manpower, he's got the smallest geographic area, and he's got the most political reasons to go after auto dealers. But the FTC's out there, and they send people on the ground. They sent their troops on the ground to dealerships in Arkansas and found that there were not used car buyer stickers on many of the used vehicles, and wound up entering a consent decree with one dealer for $98,000 in fines. But this is where it really gets troubling. The FTC is making it personal. The lawsuit they filed in California in September sued not only the dealership, but sued its principals. And this is consistent with something the Department of Justice came out with in 2015, indicating that people who were responsible should be personally liable. This again, a lot going on in this case, but as part of the sales and financing process, the defendants offered add-ons such as extended warranties, GAP, and maintenance or other service plans to consumers without their consent or falsely claiming the products were required or were free. And they said that the dealer principals were equally guilty of criminal charges in some cases, civil charges in others, a common enterprise theory. And that's not the Star Trek ship, it's the legal theory, common enterprise. Practices included deceptive sale and payment packing of the aftermarket products. So if your dealer runs into this situation, there's a chance that you personally may be liable. And your garage and insurance is not going to cover personal wrongdoing. Okay, I think we've talked about what's happened. Let's talk about what not to do, and then we'll talk about what to do. Jamming or payment packing aftermarket products into a customer's monthly payment or contract is an absolute no-no. It's going to get you a violation if the customer complains about it. Pretty much open and shut. Telling consumers they must buy a product to qualify for credit is another one. That creates the truth in lending problem I mentioned earlier, because if you have to buy it to qualify for credit, it's a finance charge. And you gotta disclose it in the finance charge box, and you gotta use it to calculate the APR. And if you don't do that, it's a $1,000 truth in lending violation and class action liability. So those are two things that you want to avoid. Let's talk about something that I've seen in some dealerships. You negotiate the monthly payment with the customer, and you and the customer agree on a monthly payment, say $500 a month. Well, that monthly payment is marked up above the allowable rate participation of the lender, but what it does is it leaves extra room in the monthly payment amount. So you negotiate the payment with the customer, and then you tell the customer the aftermarket products are free and won't change their monthly payment. Flat out unlawful. It's a species of payment packing. And it's also deceptive because of the way you got there, by manipulating the monthly payment amount. So don't do that. We've seen some of that, and hopefully those are the old days. What products offend regulators the most? Well, as a general rule, you're in the business of selling and servicing vehicles. So when you get into stuff that doesn't involve a vehicle, that's where you're going to get the scrutiny the most. Any credit repair product. Now, there's a problem with credit repair products. There's a law called the Credit Repair Organizations Act. And what it says, among other things, is that if you enter into a credit repair contract with a consumer, you can't take any money from the consumer until after you've repaired their credit. Let's not even talk about how you repair credit. But if you're charging for that product up front, what are you doing? You're taking money from the consumer before you've repaired their credit. You're automatically in violation of the Credit Repair Organization Act. So you should never offer credit repair products, because they're going to be a flat-out violation if they're itemized on the contract. Identity theft prevention products are generally considered worthless because they don't do anything a consumer can't do for themselves. They can freeze their credit files. They can put fraud alerts on. In annualcreditreport.com, you can get a free credit report from each of the 3 national credit bureaus each year, and you can spread them out by 4 months. So you'll never be more than 4 months behind looking at your credit. Do you know how many consent decrees LifeLock has entered into with the FTC? It's a lot. Vehicle etching. This one seems to come up a lot. In one class action, a dealer was ordered to pay $6.9 million to resolve the case where the dealer charged $199 for etch and concealed it with rust-proof paint sealant and fabric protection. Now you may ask, how do you get to $6 million in etching? Well, 3.5 of it went to the plaintiff's attorney's fees, the class action lawyers. Anytime you get sued by a consumer, you're going to pay your fees and you're going to pay their fees. I have a friend in Oklahoma who makes a very good livelihood suing automobile dealers for just about anything, and her fees are always paid. And she lives very, very well. Doesn't mean I agree with her, but she has a good living. Gap in credit insurance. Credit insurance is becoming something of a thing of the past. Regulators don't like it because it's expensive. And life insurance is cheaper. Term life insurance at a savings bank or another provider is much cheaper. They don't like that. They don't like gap policies that don't pay in full if the vehicle is totaled or lost. In fact, they're very skeptical of it. Service contracts have value, but not for 36-month leases. A manufacturer's warranty covers 36 months. So if you're selling extended service contracts to lessees, what value are you giving them? Nothing, because it's covered under the manufacturer's warranty. That's been an issue in cases. The New York Attorney General has flat out prohibited dealers from selling or marketing credit repair or identity protection services in connection with the sale or lease of a vehicle. So these are some of the big ones. There have been others too. Again, you have to know the value of every aftermarket product you sell and be able to defend it to me as a regulator when I come in and audit you. If you can do that, well, you need to do more than that. Think back to the rate participation situation and what we did there to protect ourselves. NADA issued a great Fair Credit Compliance policy, and it had a series of steps dealers could take to protect themselves. And you can use something similar with aftermarket products. You should adopt a policy on how you sell aftermarket products. Include scripts, include mandatory training, include disciplinary procedures for people who don't follow the training or the scripts. Use a menu and price consistently. A menu is a great thing to have because it at least shows the consumer signed off on either taking or declining every aftermarket product. Pricing consistently gets to the issue of disparate impact. Now, I realize a service contract for a Toyota Camry is going to have a different price than a service contract for a Toyota Yaris. But across the board, in the same vehicle make and model, the service contract should be pretty close to the same. Here's a best practice tip. Use your website to describe in detail your aftermarket products and describe the value of them. We know customers are spending more and more time on the web and less time in the showroom. Put the aftermarket products up there with your other stuff, with the vehicles, and encourage the customers to review those as well. Not a complete defense, but it'll certainly help you, and you're certainly likely to get some attention, and track the hits. If you don't get a lot of hits, redo those pages. I think it's a good practice and will help you. There's in my package of handouts, and there'll be a web link at the end of this presentation to how you can get the handouts, a form similar to the native fair lending form, the one that you may have seen that itemized dealer rate participation in relation to the standard rate participation amount. If you look at it, there's a template form in there that does the same for service products, aftermarket products. It lists each aftermarket product, says what the standard price is, indicates the ones the customer accepted and the price they were charged. If they were charged a lower price than the standard price, and you have a legitimate business reason, maybe the product provider was offering a sale, maybe the dealership was offering a sale, maybe the customer said, I really want that product, but I can't afford a payment higher than X. That may be a legitimate business reason. They're generally the same things that were used in the rate participation situation. Talk with your attorney about it. And that's a way to document consistency in pricing or having a legitimate business reason for lowering prices to certain customers and not others. And that's going to be one of the things that the CFPB announced that it's looking at that right now. They're looking at lender files and aftermarket product prices. It's an extension of that disparate impact theory, and it comes up in aftermarket selling. The form that's in my handouts that you can use as a template is not something you show to a consumer. It's purely in the file for your dealership's protection to show that you either sold consistently at the same price or that you had a legitimate business reason for lowering that price. It can also be done for raising the price, but I would be careful with that because it's tough to show a legitimate business reason for raising a price. And this is the rate participation certification form. It gets signed by the person who sold the product and countersigned by the program manager. Two other things to take away from this program. I mentioned there was only one, but there's three. One is to know the value of all your aftermarket products and be able to explain it. The other two are to train, and train some more, document when you're training, and document your compliance in each deal jacket. In that deal jacket, you have to have the menu. If you choose to use it, you should have that template form. Even if the customer paid standard price, put it in there standard price. So you can show in each deal jacket what happened and why what you did was perfectly legitimate. You want to review your policy and selling scripts. Some dealers videotape sales and F&I presentations. That's one that you have to talk to about your lawyer. There are pros and cons to doing that. But you should monitor your salespeople. And here's another tip. Look at your salespeople monthly commissions, month over month. If you see a sudden spike in a salesperson's commission in a month, that's a red flag. Find out why. Did they all of a sudden become smart and effective in selling aftermarket products when they hadn't been before? Or might they be doing something untoward? That happens in dealerships. And on a high level, you should monitor that as well as monitor the actual performance in the sales room. It's a good way to identify a problem before it gets out of hand. Anticipate regulator concerns. You know, the average consumer reads between a 7th and 9th grade level. So you want your materials to be written in a way that the average consumer can understand them. Plain English, short sentences, not dealer speak, and God forbid, not legalese. Be careful with non-vehicle related products. You sell automobiles and service automobiles. You don't sell identity theft protection, and you certainly don't sell credit repair. So I'd be careful with any product that isn't related in some way to a vehicle. Don't mark up prices unreasonably. I can't give you a benchmark as to what's reasonable and unreasonable. But here's something you could do for third-party products. You can ask the provider, what's the average charge that dealers that use the product charge for them? And if you're in that range, that's some evidence that your price is reasonable. But remember, it has to be reasonable in relation to the value to the consumer. We talked about service contracts. I think it's defensible there to charge a good price because the customer's buying insurance against very high cost of maintenance. Vehicle etching, not so much. Be honest and transparent. Make sure your selling scripts are at that 7th to 9th reading level and give the customer time to understand and answer their questions. And document what you're doing. Document when you train. Document who passed the training. Document who failed the training and got retrained. Document what you do to discipline employees who don't follow the training and your monitoring shows that there's been a violation of your policy. Don't just tell them to stop and not do it again. There has to be some teeth behind it. Be prepared to show your compliance. When the regulator comes in, show them your policy and selling scripts. And again, train all your sales and F&I employees regularly. I know there's a lot of turnover in some of these jobs. Nobody should be selling any products without taking your training first and passing it. Document consistently in all deals. Use the form that we have a template as a way to show that. It's not legally required, but it's something that could protect your dealership if there was ever a question. And there will be questions because consumers do file complaints. And when they file complaints, you need to have a complaint resolution process as part of your compliance management system. And when it comes to complaints on aftermarket products, there should be a strong presumption in favor of the consumer. You don't want to have a regulatory investigation over a fight over a $200 aftermarket product and price consistently to all customers. So let's summarize. Regulators are targeting aftermarket products because it's their next area of attack against dealers who they're trying to regulate indirectly, even though Dodd-Frank says they can't regulate you, franchise dealers, directly. Don't expect that to stop anytime soon. And here's the biggie, personal liability may be at risk. If you're payment packing, jamming, or quoting customers high monthly payments with room to put in aftermarket products, and they complain, look out. You need to be diligent about this, and you need to show the regulators you're being diligent about how this is working. And I know it can be tough because you're monitoring a lot of people, some of you in larger dealerships. Document your training and monitoring of F&I employees. Charge standard prices, we talked about that. And adopt the 300% rule. Sell 100% of your aftermarket products to 100% of your customers 100% of the time. Real story. Case in Michigan about 10, 15 years ago. Elderly couple comes in, buys a car. Well, Murphy's Law. On the way home, the husband who's driving the car has a heart attack at the wheel, totals the car. The wife says, "Don't come after me. If you had sold me credit insurance, of course I would have bought it and it would have paid off. You didn't offer me credit insurance, so I didn't have that chance." That case was not thrown out. That case was let to go. And if it went to a jury, I think it was ultimately settled. But you need to sell 100% of your products to 100% of your customers 100% of the time. Be transparent and use menus. Plain language, no dealer speak, no legalese, and document your compliance. All aspects of it. In each deal jacket, in your training, in your monitoring, and in your procedures, and change your policies as you learn more. Things are working, keep them going. Things are not working, you can change them. If you get customer complaints, that suggests something's wrong. Act on the customer complaints. Look at the involved people, look at the involved policies. And with that, we don't have time for questions in this audience, but I thank you and I wish you good luck. I think this is going to be the next big thing, and I wish you all luck with it. And I think if you follow some of the things we've talked about today, you'll do well. Thank you.